Okay.
Hi, everybody. My name is Seth Adams. I'm a shareholder with Woodburn and Wedge, and this is the Nevada Legal Services Bankruptcy Education Clinic. Um, Obviously, the intent of today's class is just to give you a general overview of consumer individual bankruptcy. We'll brush against a couple of topics that you could apply if you were trying to put a business that you operate into bankruptcy. But for the most part, this class is intended for folks that are considering filing bankruptcy and want to know a little bit more about it. Trying to get a handle on some of the basic terminology, figure out what you need to fill out, how you need to fill it out, where you need to take it, and the ramifications of picking one chapter of bankruptcy over another. And we'll certainly get into all of that. Next slide, please. All right, one of the kind of right out of the gate points here, some of you may already know, you may not know, there are two required classes when an individual person files for bankruptcy, and those are classes that are required under the provisions of the bankruptcy courts. You do have to take a required class before you file bankruptcy. You have to take another one right after you file. This is not either of those classes. We'll get into where you get info on that. The good news is not terribly dissimilar from today. You can take those on a computer. You can take them over the phone. And for those of you that prefer to do it in person, there are a couple options there. But this is obviously just a general overview. This is typically something that Nevada Legal Services requires of those that are looking to take advantage of Nevada Legal Services help in filing bankruptcy, or a referral for a pro bono attorney to help them out. And obviously, kind of typical attorney caveats. This is just for information. This is not legal advice. I by virtue of teaching this class, don't represent anybody who's attending. And I do advise that you consult with an attorney if you have any legal questions. All right, so if you look into pretty much anything that Congress has spoken or written about bankruptcy, they continue to refer to it, at least since 2005, as a fresh start. The whole point, regardless of what chapter of bankruptcy that you file for an individual, is to get that bankruptcy discharge. And there's a lot of confusion about the discharge, so let's just kind of hammer this point home, because it's one of the big themes throughout today. You're looking to eliminate your individual personal liability on any debts that are capable of being discharged. The key point here is you're eliminating your personal debt, your personal liability. If something is secured with collateral, the lender, the bank, whomever it is, still has rights with respect to that collateral, meaning they can still foreclose, meaning they can still repossess a car, etc. Now, there's a lot of hoops that they have to go through to get there, and we'll get into that later. But the whole point of the discharge is your personal liability. If you do everything you're supposed to do throughout your bankruptcy, at the end, when you're entitled to receive your discharge, you walk out of bankruptcy with a fresh start. You individually are no longer liable for that debt. Some of the benefits are short-term, like you see on this list here: collection, garnishment, the annoying calls throughout all hours of the day, foreclosure in certain court proceedings. All of these are, for the most part, limited or stayed or stopped outright by virtue of you filing bankruptcy. Now, this may not be permanent, and again, we'll kind of get into that later. But at least from the get-go, the moment that you file bankruptcy, you are protected from most of these forms of debt collection. Other opportunities in bankruptcy, you may be able to renegotiate or change some of the terms of any of your debts. And you may also, for things that you want to keep, for instance, a mortgage, this may give you the opportunity to catch up on those back payments and do it in a manner where you're not simultaneously risking getting your house foreclosed upon. Next slide. All right. These are kind of a common thread of things that I've heard over the years of, things that frankly undermine somebody filing for bankruptcy. The first one is kind of a big one. If you are already judgment proof, and that's kind of just a a legal phrase that we've assigned to people where, either there are sufficient assets for a creditor to really justify going after you in trying to collect a debt. And related to that concept is Nevada entitles everybody to certain exemptions. If everything that you want to protect, and I'll kind of put air quotes around that, everything you want to protect, like your house, your car, your household goods, your retirement account, etc., if everything falls into one of these categories that Nevada has set up for exemptions, you are, for all intents and purposes, judgment proof. So this creditor could go to court, they could obtain a judgment against you, but when it comes to executing on that judgment, well, there's nothing they can necessarily reach. So for certain folks, if you're able to live with the annoying telephone calls, if you're able to live with, receiving the notices in the mail and so forth, if you have all of your assets that you want to protect nice and categorized in one of those exemptions, the choice of filing bankruptcy is up to you. If you want to stop all those calls, discharge those debts, and start again, great. But the net result of what a creditor will be able to reach may not be all that different. The flip side of that, another reason that should give somebody pause in determining whether they want to file bankruptcy, is if you have assets that don't fit into one of those exemption categories, and these are things that you want to protect, but like I said, if it doesn't fit into one of the categories, then you have to make a real hard decision about, do I file bankruptcy and potentially forfeit that asset? What am I going to try to do? And the easiest example I can give is everybody that files bankruptcy using the Nevada exemptions is entitled to protect a car, so long as that one car doesn't have more than $15,000 in equity. That's not value, that's equity. So beyond whatever is encumbered, it doesn't have more than $15,000 worth of equity. Well, let's say you have two cars and you're filing individually, you're not filing with a spouse or anybody. Well, if you want to protect both cars, you've got a little bit of a problem because, again, you're only allowed to protect the one. So that may weigh into whether you determine you want to file bankruptcy or not. A third reason here, we'll talk about the difference between the chapters, but a Chapter 13 bankruptcy, unlike a 7, does require ongoing monthly income. So if, and again, we'll talk about what a 13 does that a 7 doesn't, but if you determine that you need to file a 13, but you don't have ongoing regular monthly income, again, you're kind of stuck in the gate of not being able to file a 13 until that income situation changes. The last kind of big stumbling block to filing bankruptcy is if you have received an individual discharge in the previous 8 years, I believe the code actually reads 7, but you do need to wait in order to obtain another discharge. Now, there may be reasons to file bankruptcy other than obtaining a discharge. For instance, if you obtained a Chapter 7 discharge previously and you need to file a 13 in order to, let's say, catch up on your mortgage, you may be able to do that. You just won't get to the end of that second bankruptcy and receive another discharge unless there's been more than basically an 8-year gap. So that also comes into determining when you file bankruptcy, because this is, kind of a big jump. And once you make this leap and once you obtain your discharge, you do need to wait, another 8 years before you file bankruptcy and obtain a discharge again. All right, some common myths, and unfortunately, I've heard these and continue to hear them pretty often. I tend to find myself representing creditors more often than not in bankruptcy, but I do often meet with people that have filed bankruptcy, and we have these unfortunate conversations in the hallway when they already filed bankruptcy and believed one thing or the other, and come to find out that it's not true. So one of the things I hear quite often is, I don't have to file bankruptcy against all my creditors, or I don't have to include my house. My house isn't in my bankruptcy. Common misconception, you do not get to pick and choose what assets or interests of yours are in bankruptcy. Once you file bankruptcy, everything is in bankruptcy. I mean, the joke is everything from your 401k to the change in your pocket is included in your bankruptcy. You do not get to pick and choose. And the downside to not listing a particular creditor, for instance, you tell yourself, I'm going to file bankruptcy, I'm not going to list this creditor, then I'm going to obtain my discharge, and then when they come knocking, I'm going to waive my discharge in front of them and say, ha, 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 you can collect against me. I received my discharge. Big misconception, and it's just patently false, because if you don't list a creditor, at least to the best of your ability, provide an address for them so that the both you and the court can provide them notice of the filing of bankruptcy and give them notice when you obtain your discharge. The discharge, frankly, doesn't apply to them. So, you've gone through the hassle of filing bankruptcy, doing everything you're supposed to, obtaining your discharge, only to not be able to actually block the collection efforts of the creditor that you tried to slide one past. With not including assets. So if I say, oh, my house isn't in my bankruptcy, everything else I have is in bankruptcy, but not my house. If you don't list it, and the trustee, and we'll talk about what a trustee is in a minute, if the trustee gets wind that you haven't filed or haven't claimed a particular asset as part of your bankruptcy estate, they can frankly just take it. And that could be the least of your problems. It could go so far as to prevent you from getting your discharge. So imagine that. You forfeited an asset that you can no longer protect, and you're going to continue to go through bankruptcy. The trustee is going to liquidate what he or she can liquidate of your assets. And then at the end of it, by virtue of having misrepresented your assets to the court, you will not get your discharge and will be, frankly, kind of kicked out and left for the wolves that are the creditors, because you will not obtain that discharge. So absolutely 100% list all your assets and list all your creditors. The bottom two here are kind of just the same thing. We talked about how one of the short-term benefits of filing bankruptcy is to stop collection, stop foreclosure, stop repo. These are not necessarily permanent benefits. We'll talk about what the creditors have to do to get there, but do know that there is a path. If those creditors want to continue on with those efforts, they can do it. So there's a couple of terms I've already thrown out, and here's just really scratching the surface. There's a really good glossary, and we'll talk about the particular website that is for the District of Nevada Bankruptcy Court. There's a whole litany of bankruptcy basic info on there, including a glossary of all the terminology. This is just a snapshot of kind of the basic things you need to know for today. So first and foremost, a debtor. When we talk about a debtor here, for any of you that have heard debtor in the context of accounting or anything like that, kind of put that out of your mind, because a debtor here is anyone who files bankruptcy. If it's a company that files, they're a debtor. If it's a person that files, they're a debtor. You will hear that term all the time, and you'll see it in a lot of the forms. The next two, the petition and the schedules, and we'll show you some examples of what those look like. Those are the kind of loose terms for the papers that you file to start your bankruptcy. The petition's the basics: name, birth date, social security, etc. Schedules and statements are really the rest of it, where you're listing all your debts, you're listing all your assets, you're listing your income, you're listing your expenses. Your estate, that we'll talk about in just a second, is frankly everything that you have once you file bankruptcy. An estate gets open. And then again, the rest of these we'll go through as we get along. We did already talk about the bottom discharge there, and a plan. I'll just plant this seed right now. When we talk about a plan, a bankruptcy plan of reorganization, you only need to worry about that for a Chapter 13 or a Chapter 11. Next slide, please. All right, so the bankruptcy estate. I tend to need a visual, and if you're a visual person as well, think of an invisible bubble. The minute that you file bankruptcy, this kind of invisible bubble swallows not only your tangible property, so all your house, your car, your household goods, your tools for work, but also things that are intangible. So if you've got an interest in an estate, if you've got the ability to file a lawsuit that might be worth money. If the example I use is right before I file bankruptcy, I get my foot run over by a city bus, and I've got the ability to file a lawsuit, but I haven't done it yet. That has some value to it. That is included in my bankruptcy. If I've ever written a screenplay, if I've written a song, anything tangible or intangible goes into this, again, my wording, invisible bubble or bankruptcy estate. And then you determine what you can exempt and kind of take back out of it. But this goes into one of those bankruptcy myths that, again, when you file everything that you have an interest in, whether you can actually hold on to it or not, whether it's actually been realized or liquidated yet, it is included in your bankruptcy estate to start with. Now, this bankruptcy estate is why we get a Chapter 7 or a Chapter 13 trustee appointed to us. It's his or her job to administer that estate. And we'll talk about a little about what trustees do and how they do it. But for the most part, that's the point, particularly in a Chapter 7, of what the trustee's job is. They're going to figure out what of the things that are included in your bankruptcy estate are things that they can liquidate, i.e. things that aren't exempt. What can they liquidate to get money to pay out to your creditors? Now, that money that they get to pay out to your creditors obviously might be pennies on the dollar. It might be the entire dollar. It all depends on what the trustee can get and liquidate in your bankruptcy estate. Next slide, please. All right, I have already bumped again the trustees, and one thing to let you know, we do use the term trustee in bankruptcy kind of redundantly to talk about two different kinds or two different types of trustees. When you file a Chapter 7, you get a Chapter 7 trustee assigned to you. When you file a Chapter 13 trustee, you get a Chapter 13 trustee assigned to you. Up here in Reno and Northern Nevada, there's only one Chapter 13 trustee. So you're always going to get the same one there. Chapter 7, on the other hand, there's a panel of trustees, and they get randomly selected when you file by the U.S. trustee. You usually won't have a lot of interaction if you file a bankruptcy with the U.S. trustee's office. What their job is to do is to kind of monitor the entire bankruptcy process and make sure that everybody is playing by the rules. If you do one of those things that I already admonish you not to do, if you don't disclose an asset, if you previously received a discharge only a couple years ago in a different state and you're trying to file again, the U.S. trustee's office is really investigative. They are looking over everybody who files bankruptcy and again making sure that they abide by the rules of the road. The other term, again, we talk about a plan. You're only going to worry about that if you file an 11, 12, or 13. But when you do, let's say a Chapter 13, you're trying to reorganize your debt. You're trying to take some, maybe change the interest rate, change the term a little bit. The other things you're trying to pay, any pennies on the dollar that you have after your plan payment and your disposable income. Discharge, again, I just want to hammer this point one more time. You're only talking about your personal liability. And the second caveat to this is only on debts that can be discharged. Not everything can be discharged. And we'll talk about that in a minute too. Next slide. All right, to that end. So you'll see if you've ever even started on your statements and schedules to file bankruptcy, they are split up into different kinds of debts: secured debt, priority debt, unsecured debt, administrative debt. Secured debt is frankly an easy one to think about. That's something that has a right that was secured before bankruptcy in some kind of collateral. A car loan or a mortgage are examples of secured debt. The other one, the flip side of that, unsecured debt. Anything that is frankly just based upon your promise to pay, a credit card, a personal loan, that kind of thing. Administrative claims, usually not terribly difficult, and you may not have a lot of that, but the trustees do get paid a claim based upon the value of your estate. That's to pay for them doing their job. If you're paying attorney's fees, and if you're paying that through your plan, your attorney may have an administrative claim. So again, it's just for certain administrative expenses. The other one, the priority, those are certain classes of debt that the federal government has given priority to, i.e. child support, federal tax debt, things of that nature. Those debts will get paid, frankly, above and beyond everybody else. More often than not, and at least right now, we'll see if the coronavirus and COVID become one of the predominant reasons for folks to file bankruptcy. But at least for the last couple of years, medical debt has been, at least based on the things that I've read, the number one reason that individuals file bankruptcy. They will have some sort of a medical event, they will incur a tremendous amount of debt, and they will believe that they need to file bankruptcy. Spousal support, alimony, and child support, again, typically non-dischargeable in bankruptcy. But if you can use bankruptcy to get rid of other debts, You can get rid of credit cards. You can possibly surrender a vehicle if you need to. You can get rid of personal loans, and that then frees up more of your income to be able to address spousal support and alimony. Again, might be a good reason to file bankruptcy. School debt, i.e. federally guaranteed or insured educational debt, typically non-dischargeable. We're starting to see a little bit of a light in the tunnel, allowing certain folks with exigent circumstances to discharge all or a portion of their debt. It is, frankly, something that is very rare. Even in the West Coast states, which have tended to allow more discharges of school debt than others, it does take a pretty serious set of circumstances, i.e. you have tried to go through your particular lender and make some sort of payment plan over the years. You haven't been able to catch up. Your prospects for employment don't look good necessarily. You've had some sort of large medical or life event, those kind of things. The other thing to take into consideration is if your educational debt is purely private, i.e. not federally guaranteed, then frankly, it in all circumstances may be able to be discharged. Taxes, federal taxes in particular, almost, well, not almost, I won't say that, very difficult to discharge. You know, certain taxes, frankly, cannot. Certain payroll taxes in particular, if you were employed, those may be almost impossible to discharge. Income taxes. There are certain taxes after they meet certain criteria that can be discharged, i.e. income taxes. They do need to be a little bit older, at least 3 years, I believe. They need to, you need to have filed a tax return for them at least 2 years ago. And the IRS actually has to have, I don't want to say finalized, that's a bad word, but they do need to have recognized what your tax liability is. And we won't get too far down that rabbit hole, but what I'll essentially say is if you are still in the midst of a dispute with the IRS and they haven't yet determined a finalized tax liability for you, you may need to work through that process before you ever think about pulling the trigger on bankruptcy, because until they do so, they are not yet ripe for discharge. The last category here, a judgment. We talked a little bit about what happens if a creditor sues you. Let's use the example, if they sue you in state court for, let's just use American Express. American Express sues you, they will obtain a civil judgment against you. The judgment's just a piece of paper. However, when they actually use that piece of paper to execute against you, i.e. they're going to try to garnish your wages, they may obtain certain writs that allow them to go after your property. That's obviously where the rubber meets the road, and bankruptcy can come in and kind of stop that process, at least temporarily. However, there are certain kinds of judgments that you can't discharge, certain acts, intentional acts. One of the big ones is if you were behind the wheel in a DUI situation, you hit someone and you caused them injury. That is one of the specific kinds of judgments that the bankruptcy court doesn't allow you to discharge. Again, you may be able to use bankruptcy to deal with your other debts to free up money that you can then begin to use to pay down that judgment. But it is something to absolutely positively take a look at. If you have already had a judgment obtained against you, you need to make sure it's not one of the types that is non-dischargeable. Next slide, please. All right, we grazed against the topic right out of the gate, talking about exemptions. Exemptions are great. There are federal exemptions, there are state exemptions. In Nevada, we almost exclusively use Nevada exemptions. And the good news is Nevada exemptions compared to the other states are actually pretty darn good. I put the little Nevada revised statute 21090 if you want to take a look at them yourself. There are a list of all these different exemptions. But again, keep in mind with my previous description of what would make somebody judgment proof, these exemptions apply whether you file bankruptcy or not. So keep that in mind. Next slide. All right, here's just a smattering of frankly, the most popular ones. This isn't the entire list, but the one that a lot of folks have already heard of before is called your homestead. In Nevada, you're talking about a significant amount of equity, similar to what I discussed with the car. It's not looking at the overall value of your house. It's looking at the difference between what it's worth minus what you owe on it, i.e. the equity. Taking care of your homestead is really simple, and I 100% recommend filing and recording your homestead before you file bankruptcy. Last time I checked with Washoe, it was only 17 bucks. You take a quick trip to the county office. That might be a little different these days, but you take a quick trip to the county facility, you pay the $17, you fill out your homestead, they record it for you, and boom, your homestead's finalized. Other exemptions, we have a household goods protection up to $12,000. A vehicle, we already talked about that one, up to $15,000 in equity. We're Nevada, we're the Wild Wild West. So of course you get to exempt a gun no matter what the value is. Obviously, pick your most valuable gun. It will be exempt. You may be able to protect your other guns. We'll talk about that if that's something that you need to do. Certain retirement accounts, and I will probably change the word certain to say most. If it's a federally recognized retirement vehicle, like an IRA, 401k, a SEP plan, so on and so forth, almost always that retirement account is exempt. Contributions to it may be taken into consideration as far as your income, but again, that's something that doesn't apply to everyone. Tools, equipment, and inventory. If you use those tools for a job, you use it for your employment, or you used it previously for your employment, you can protect up to 10,000 bucks worth of that stuff. Social Security income, other public benefits, better put a caveat on public benefits. They do need to be recognized by the state. So these are for the most part, state or county issued public benefits. Most life insurance. If you have a life insurance policy, unless it is immediately transferable to cash, i.e. I can just call them and immediately liquidate a cash value, almost every other kind of life insurance policy is exempt. And then my biggest change to my slides here, Nevada has a wild card exemption. It used to be 1,000. It's now 10,000. And so that wild card exemption allows you to protect up to $10,000 in current value of anything. That may be your most recent tax return. That may be your second gun. That may be your second car, whatever. If it all collectively, and it obviously can apply to multiple things. So if you have 4 or 5 things that you can't otherwise fit into these other exemptions, you will be able to slide it into your wildcard exemption and hopefully, again, keep that as something that you're able to use in your fresh start. Those won't be assets of the portion of your bankruptcy estate that the trustee liquidates. Next slide. All right, I've already talked a little bit about we've talked about there being a 7, we've talked about there being a 13. For the overwhelming majority of you, you will be choosing between a Chapter 7 or a Chapter 13. There are other chapters. Frankly, there's a litany of other chapters, most of which rarely ever get used. So we'll talk about the 2 biggies here primarily for the rest of the presentation. A Chapter 7, just think liquidation. You're filing bankruptcy, everything that's not exempt, the trustee is liquidating, getting some money, doling that money out pro rata to your creditors, assuming you've done everything else you need to do, you get your discharge, you're done. Chapter 13, on the other hand, you're trying to reorganize things. Again, you're trying to change terms. You're trying to pay certain things while paying others less or none. The Chapter 11, an individual can file a Chapter 11, but you better have a pretty good reason for doing it. It's a lot more expensive, it's a lot more arduous, and it lasts a much longer period of time. I put in Chapter 9 and Chapter 12. Chapter 9 is when a city files bankruptcy, so you may see that in the paper from time to time. Chapter 12 for family farmer or fisherman, we do get a handful of Chapter 12 cases every year in Nevada. Everything from pecan farmers to just about anything else of a recognizable crop. If that is you, if you have and derive income from some sort of plant or vegetable, nut, etc., that you harvest and obtain money for, definitely talk to an attorney, because if you can qualify for a Chapter 12, you can do all kinds of things in a Chapter 12 that you can't do in a 7 or a 13. They really made a kind of special carve out for family fishermen and our family farmers and fishermen. Next slide. All right, the big 2, the differences between a 7 and a 13. A 7 is much quicker. Depending on the current caseload on the court, depending on the complexity of your bankruptcy estate, you may be able to get in and out of Chapter 7 in a relatively short period of time. And what I mean by that is sometimes 4 to 6 months. That's not everybody. Sometimes your Chapter 7 case will be open much longer before you obtain a discharge if, let's just use as an example, the Chapter 7 trustee is waiting for your tax return to come in to see if any part of that the trustee might be able to liquidate and again dole out to creditors. But for the most part, it's much, much quicker than a 13. A 13, on the other hand, you really have two different flavors. You have a 3-year plan or you have a 5-year plan, meaning you will be making payments towards your plan when you come up and develop your plan and say, okay, you know, after all my household expenses, my rent, my car payment, my insurance, my food, my this, my that, I've got this much in disposable income. I'm going to pay that disposable income into the Chapter 13 trustee, and I'm going to do that either for 3 years or 5 years. So obviously, it's a much longer period of time that you will be, you know, kind of joined with the court. Now, I'm not going to say that in a 13, you know, you're going to court every week. Almost certainly not. You're going to file bankruptcy just like you would in the Chapter 7. You're going to go one additional step of proposing that plan. That plan's going to hopefully be confirmed by the court. It'll be, you know, if it's allowed. And then you will just make that one payment a month to the Chapter 13 trustee, who will then dole it out to your creditors pursuant to the terms of your plan. For the most part, you know, you're 13, that may be the only 1 or 2 times that you've ever gone to the courthouse. So, you know, with neither one of these 2 chapters will you have to go to the court all the time, unless, again, there's a problem with the documents that you use to file bankruptcy, you hid an asset, they don't like the Chapter 13 plan you proposed, etc. Usually your only time to the courthouse is when you filed, and then what we call a 341 meeting that I'll talk about. Chapter 7 case doesn't have a plan at all, and at the end of the day, you're both trying to get that in personam or personal liability discharged. You can get that done in the 7 or 13, but in the 13, you may also be able to modify certain secured claims. Your car loan, and in some instances, you know, if you have a second mortgage on your house, you can modify that in a 13. Can't do it in a 7. Next. All right. The pros of Chapter 7. Again, you got that 4 to 6 months, 1 trip to the courthouse. Unless you go file it yourself, then you'd have 2. Downside. If your property you can't fit it into one of those exemptions, you're almost certainly going to lose it. You don't have the chance to kind of catch up on something. So if you had a medical event and you got 4 months behind on your mortgage, Chapter 7 may not work for you unless you can, for instance, file a Chapter 7, take the money that you were using to pay on an unsecured debt that you're going to discharge anyway, and move that money into your budget to be able to catch up on your payments. But if you've got a bigger period and not a lot of income to do it, a Chapter 7 may not work for you because, again, you're not reorganizing anything in the 7, you're liquidating. And again, you've got that bar on obtaining another 7 discharge for 8 years. Next. 13, you get to keep not only your exempt property, but you may be able to keep things that are not necessarily exempt, but you do need to make certain concessions to do that. You know, obviously it can't be something that has a tremendous amount of value to creditors of the estate, because if you owned a house free and clear, obviously that may be something that the Chapter 13 trustee is considering as of more value to the creditors in your case. You have the ability to pay off back taxes, again, with those caveats that we talked about before. You can catch up on, you know, child support, catch up on your mortgage, and you're going to get that same fresh start, but it's going to take you 3 to 5 years to get there. It is more complex. It's harder to propose a plan. The Chapter 13 trustee and the U.S. trustee and your creditors are going to scrutinize your income and expenses. If I am filing individual, let's say I didn't have a family, and I'm claiming that I spend something kind of silly like $5,500 a month on food, they are going to intervene and say, that's ridiculous. You do not need to spend $5,500 on food. We're going to reject your proposed budget, and you need to go back to the drawing board or else. And to that end, the courts do look at IRS standards of living both in determining your eligibility for filing certain chapters of bankruptcy and in looking at your claimed expenses. They don't hold you to the letter of the law and say, oh, you can only spend X if you have a family of 4 that lives in Washoe, but you better be pretty darn close. And if there is a variance, you need to be able to explain what those circumstances are. You know, my mother now lives in our household, or we have a high prescription cost. That's why our medical is much higher on a monthly basis. You need to have a justifiable reason for those expenses. The con or pro, depending on your particular viewpoint, is in some instances, you're making just one payment to that Chapter 13 trustee, who then is responsible for doling it out to your creditors. Some people prefer to have the control. Sorry, you know, once you file a 13, you are making those payments through the Chapter 13 trustee. The only exception being that if you are already current on certain secured claims, you can continue paying those. Like if you're already current on your mortgage and car payment, you can make those payments directly to those creditors while you're taking a portion of your disposable income, i.e. your plan payment, and you're making that payment to the trustee. Next. All right, I won't go too far down this rabbit hole either, but I talked a little bit before about not everybody gets to qualify for filing the chapter that they choose to file for. And what this typically means is people that make more than a certain amount and have a greater than a particular threshold of disposable income may not be able to file a Chapter 7. They may get pushed into a Chapter 13. We call this process the means test. And if you fill out your statements and schedules yourself, you'll see the means test. If you can fill out the first couple pages of a tax return, you can fill out the means test. You'll put your income in there, you'll determine your household size, et cetera, et cetera. And there are kind of 2 tests that we're talking about here. If your annual income is below the median income, basically looking at the state and even the county in which you live in, and your family size, you may be able to choose whether you go 7 and 13. If it's above that average median income, then you go one step further. Next slide. The next part, and again, I'm sure we can distribute these slides if anybody wants to, but what they're looking at is, okay, if you're already above this median average level based on, let's say, a family size of 3, then the next step is how much disposable income you have. You might have 2 different families of hold up the proper amount of fingers, Seth. You might have 2 families of 3, but they have drastically different income and drastically different expenses. If one family of 3 has much larger expenses, they're going to, as a related concept, have much less disposable income. They may be able to pass and go into a Chapter 7. But if somebody has, again, above median income and has a greater than kind of the allowable threshold in disposable monthly income, there is going to be what they call a presumption of abuse, meaning you make too much and you have too much in disposable income. It's not fair to your creditors for you to file a 7 and wipe them out. You need to go into a 13 and take some of that disposable income and pay it over 3 to 5 years to your creditors. Excuse me. Now, it's called a presumption of abuse. You may, like we talked about before, have exigent circumstances that justify why you should be able to file a 7. A lot of times it's you just had a job loss. You just incurred a lot more medical expenses. Your household size just increased. We see that a lot, particularly in Nevada. All of a sudden, empty nester parents now have their daughter, her husband, and their 2 children moving into their household. Expenses are going to bloom. Again, there may be circumstances where you can explain your situation and may be able to file the 7. There's also debt limits, and these change frequently. Frankly, they have changed already from these slides. But if you're in the neighborhood of $400,000 in unsecured debt, or 1.2 in secured debt, you may get pushed into a 7 or an 11. Again, more of a complicated situation, but if you have a large amount of debt, definitely take a look at the debt limits for the chapter that you want to file in. Next. All right, a couple of pre-filing details to know before you get there. There's a cost, a fee that you pay to the court. Chapter 7, 335, Chapter 13, 310, Chapter 11, you'll see all the way up to 1,700 bucks. These have nothing to do with your attorney's fees. They're not including the fees that you'll have to pay to take your required classes. These are just administrative fees that get paid to the court. In case you're wondering why, if a Chapter 13 takes so much longer than a Chapter 7, why a 13 is so much less, well, that's because you'll be paying in some over time as well. But these are just what you need to show up with when you file. Next. All right, you can, if that's if that 335 or 310 are too much to bite off right out of the gate, you can apply for a waiver. There's a special form that you fill out. You file that when you file your bankruptcy petition. If your income is less than 150% of the poverty line, again, that's a constantly changing IRS standard. Frankly, these figures right here are about 5-6 years old, so take them with a grain of salt, but that'll give you an idea, i.e. if you make less than 17.6 and you're just filing individually yourself, you may be able to apply to have that fee waived. Almost everybody can apply to have it broken up into installments. The other big change I'll say with this, you are breaking it into 4 installments. They have changed the first installment to be due immediately when you file. So you'll see here, I have the 30, 60, 90, 120. They have changed that. You now need to file at least the first installment of 80 bucks right when you file. But if breaking it up into 4 instead of paying the whole 335 would be helpful, you can do that. Next. All right, things to do. There's your to-do list before you file bankruptcy. Got to organize your debts. This is not an easy task. For the folks that I do help file bankruptcy, this is, almost certainly one of our hardest things to do before you file. Collecting all of that stuff that you've been inundated with, that you've received by mail, the bills, the statements, the threatening letters, etc. Try to, if you can, match up a particular debt statement with the collection notice, with the attorney's notice that represents them. So, for instance, if you had a Best Buy credit card, Best Buy may refer to collection company, and then collection company may refer to legal to threaten a lawsuit against you, and or file and obtain that judgment. Try to organize them accordingly, because when you fill out your statements and schedules, obviously you want to list everyone. You want to list the collection company, you want to list the attorney firm, so that everyone gets notice and they stop, with the calls, they stop with the letters. But those would just be additional parties that you're giving notice to. You don't have a separate debt with Best Buy, the collection company, and the attorney. You just have that debt with Best Buy for the most part. Always, 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 before you file bankruptcy, pull your credit report. Everybody is entitled to a free credit bureau report from the 3 major bureaus each year for free. That's this annualcreditreport.com. You can call them, you can go on the internet. There is a form that you can download, fill out, and send in to get it. I would just recommend, if you've got computer access, go through it. A lot of people have asked me, these forms are kind of ugly. Is it all right? Or is there any downside to me paying 30 bucks to, Credit Guru or any of the other litany of companies to get my bureau report? Not at all. I mean, if it makes it easier for you to get the final product, great. But just know that there is a free option out there. The reason you want your credit bureau report, because that is at least the starting point to list every single debt that shows up on there. My humble recommendation is list it even if it shows as charged off, shows as 0. Again, your discharge, your end goal doesn't apply unless you list the debt. So list everything. The other big to do, organize your assets and all your income documents. With assets, think about everything that you have that is of great value. When you fill out your statements and schedules, you'll have to list your assets. They're not asking for a breakdown of every bowl, fork, spoon, plate, blender, etc. That would all kind of fit within household goods. But they do ask you to estimate what the approximate value of that is. So if I think of all my kitchen goods and my other household goods and I say 3,500 bucks, I'll put that on there, and for the most part, the court is going to defer to your opinion. Income documents, huge. When you go to your 341 meeting, and we'll talk about what that is, you need, in advance of that meeting, you will get a list from the trustee that says, 2 weeks before your 341, I need your pay stubs, bank statements, tax returns with all pages. If you lease where you live, if you lease your apartment, I need a copy of that lease. For every vehicle that you own, I need a copy of the title. I also need an appraisal, or Kelley Blue Book or nada.com. I need some sort of value that tells me what that car is worth. If you've got somebody staying with you that pays you a little bit of money, like a tenant or boarder, you need to have proof of that. You need to organize all this stuff, and you need to have it ready to go, because if you don't have it by the time you show up at your 341 meeting, you can risk getting your case dismissed. Usually you'll get one more bite of the apple to they'll move your meeting another couple of weeks, but boy, oh boy, if you don't produce it by the time the trustee really requests it of you, you run the risk of not being able to go forward with your bankruptcy. There is an NLS bankruptcy package that has a list of items. The trustees, the Chapter 7 trustees in particular, have in Reno at least, have gone to using the same checklist. But again, really think about all those important documents. To the extent that you can get them all organized before you file bankruptcy, you will make your life a lot easier. The second you get that questionnaire from the trustee, you fill out the questionnaire, you attach all the documents, you bring it to them, you mail it to them, you email it to them, and you show up at your meeting, and it'll make your life a lot easier. Next. All right, I told you this wasn't one of your required classes. Here's a little info on the two that are. There's a pre-bankruptcy credit counseling class. You can do it online, you can do it over the phone. There are still a few places in Northern Nevada where you can do it in person, but frankly, if you've got access to a computer for a couple hours, definitely do it online, make your life a lot easier. There are a handful of entities that you can do it with. The average that I looked at was around 24 bucks. There are some that charge, 40, 60 on up. They typically have a little bit more in-depth knowledge. So if you're looking to kind of do the bare minimum, you may pay around 24. If you're looking to have a little bit more in-depth conversation to determine whether you need to file bankruptcy, you might be looking a little bit towards the 40, 60, 80 on up type of expense. On the Justice Department website, justice.gov, or the bankruptcy court's website that we'll look at in a sec, there is a link to the approved agencies that provide counseling. They also do it for the second class that we'll talk about. That is the starting point that I tell everybody. If you don't already know of a place to go, or the attorney that you're working with doesn't recommend you using a particular place, make sure that they're an accredited institution, so you're not just sending your money off for nothing. You have to obviously get the pre-bankruptcy class done before you file bankruptcy, and you are going to obtain a certificate once you get through that entire class. You will be filing that certificate with the court, and you have to do that, frankly, really quickly when you file bankruptcy. You should file it when you first file your petition. That certificate, I believe they've shortened this window a little bit. It used to be 180 days. I believe it's now 120 days. But for people that are still collecting all of their income data and they're still starting to work on their petitions and schedules, I say take a day off or take a weekend, go ahead and go online, pick a vendor, get this class knocked out, because then you have at least 120 days before you have to file bankruptcy, because that certificate will go stale. But you might as well knock it out when you have a free day. The second class is called Personal Financial Management / Debtor Education. Again, 25 bucks, somewhere in that neighborhood. You can pay more if you want to pay more and look at the other features that the other place offers. They will almost always make a little bit of a 2-for-1 type of deal. So 40 bucks if you're filing jointly with a spouse, for instance. You take the second class after you file, but before you get your discharge. And frankly, it's within 60 days of that 341 meeting. So again, humble recommendation. Most of the work of filing bankruptcy is before you file. You'll have taken your pre-class, you'll get your petition and schedules all filled out, you'll get your certificate, you'll file all of the stuff with the court, you'll pay your filing fee. Once you do all that, you've officially filed bankruptcy. Go ahead and take that second class. You'll get your second certificate, you'll file that. And then, frankly, if you've done everything right, you'll sit back and wait. And the trustee will obviously let you know if they have any issues with the information that you filed with the court. Next. All right, you may not be able to see these super well depending on the size of your screen, but I just wanted to show you what a few of the required forms look like when you file bankruptcy. We talked about a petition. Again, petition's real basic. Name, address, social security number. This is where you're filling out what chapter of bankruptcy you want to file for. You're listing a ballpark idea of how much your assets are worth altogether. And then you're listing a ballpark amount of how much in total debt you believe you have. And this, frankly, is kind of serving like the cover sheet so that the court knows, all right, Seth Adams wants to file a Chapter 7. He lives in Sparks, and he's got, you know, 50,000 in debt and 20,000 worth of assets. And that's kind of the guide. Next. You'll also notice or you may or may not notice, but in 2015, we adjusted the forms. If you are filing for a business, there are now different forms that you fill out, and they'll be referred to when you look at the difference between the individual forms. They're called non-individual forms. So if you're not an individual, i.e. a corporation, LLC, so forth, you're going to use the non-individual forms. Just something to recommend to you, because when you go onto the court's website, you will get linked around a little bit to the official forms, is what it's called. And you will see individual filing bankruptcy, non-individual file bankruptcy, individual schedule this, non-individual schedule this. So remember, if you're a human being and you're filing a bankruptcy, you want to make sure that you've got the word individual before every form that you take a look at. The other big caveat about your petition and your statements and schedules, you really don't have to pay for these forms, folks. They're free. They're fillable PDFs on the court's website. You can download them, print them out, fill them out by hand if you want to. You've got good handwriting. But you can also, you know, fill them out right there on the computer and save them to your desktop. So whatever makes your life easier. But gone really are the days where you go to a bookstore like Barnes and Noble and you pay $35 for the official bankruptcy forms. You don't have to pay for them. Next. All right, we're not going to look at all of the schedules, but again, you'll remember after you file your petition, along with that are certain statements and schedules. The schedules are where you list all of your assets and all your liabilities, and they're broken up by what it is that it's asking you. So you'll fill out a schedule A, B, you'll list your any kind of real property like your house. You'll list your personal property, again, the big stuff, cars, so on and so forth. Next. You'll have a schedule C. This is where you claim all your exemptions. So I'm going to list, my house in Sparks. I'm claiming the homestead exemption. This is how much I think it's worth, etc. Next. Then you'll do, if you file a Chapter 7, a statement of intention for anything that's collateralized, i.e. anything that's got a security interest in something to secure your payment on that loan. You, in a Chapter 7, need to tell the creditor what you plan on doing with it. We'll talk a little bit about the difference, but you can surrender it, you can retain it, or you can retain and enter into a reaffirmation agreement. There are significant differences between these. Next. To that end, so if I file a Chapter 7 bankruptcy and I have a car loan that obviously has a lien listed on the title to my car, until I pay the whole thing off, they're going to have that lien on my car. When I file a Chapter 7, I'm filling out a statement of intention and saying, hey, do I want to keep it or not keep it? If I don't want to keep it, i.e. I want to surrender it, I'm basically giving notice to the creditor, hey, come pick up the car. We'll talk a little bit about how that works in reality. More often than not, the credit union, the car loan institution, or their attorney will reach out to your attorney if you have one, or you, and say, hey, noticed you wanted to surrender the Ford. Is it okay if we come pick it up? Would you like to drop it off? We can have a tow truck come fetch it. They'll make arrangements with you, but you can do that, keeping in mind that, when you're a Chapter 7 debtor, if I don't want to pay for this very expensive car that I got, I can't afford it, I need to be able to basically turn it over to the lending institution, and I'm no longer going to be personally liable for it, regardless of how much they actually go repo and auction it for. That may be the perfect method for me to be able to do it. I can wash my hands of it completely. The other options are a little bit different. If I want to keep something, the creditor may require me to fill out what they call a reaffirmation agreement. You got to be really careful with a reaff. This is where you're taking back on the personal liability for one particular debt. Whomever you're entering into that reaffirmation agreement with, you're agreeing, even after you obtain your bankruptcy discharge, to still be personally liable on a debt. You may really wonder why on earth you would want to fill one of these things out. As a debtor, you almost never want to fill these things out, but you may be required to do it, or, and a really big reason to do it, it may be a requirement to get your loan modified if you're doing a mortgage. And frankly, even bigger these days, if you reaffirm the debt, in most instances, the creditor will continue to report positively when you're making payments to your credit bureau. So look at the fine print. If you have an attorney, they will almost certainly counsel you about reaffirmation agreements. They almost always only come up with cars and houses. If it's a car that you plan on keeping, you have a good interest rate, it's a good car, it's in good condition, you'll look at the fine print. Do they have the right to repo if you don't enter into a reaffirmation? Perhaps, technically. Will they if you're actually still making payments? Probably not. But if you think about what you need to try to do after bankruptcy to reestablish a good credit bureau score and good credit history, you're thinking, I only have a $210 payment, I got a 4% interest rate, it's a good solid running car, I'm going to go ahead and enter into this reaff, maybe I'll get positive credit bureau report. But if I have a car that's tremendously underwater, it's breaking down all the time, I've got a 20% interest rate on it, and frankly doesn't make any sense to me to continue to keep it. If I want to surrender it, I can, but that may also weigh into, if I do need to keep it, at least temporarily, you may not have an interest in reaffirming it. And frankly, our judges up here in Northern Nevada will almost uniformly not approve a reaffirmation if they don't believe it's in the debtor's best interests. The last option is what we call redemption. It's not used all that frequently, but this allows you to enter into a deal with the creditor where you're basically paying them the current value of something in exchange to retain it. This comes up a lot, I see, with used furnishings and bedding. So let's say you got a super fancy bed that raises and lowers and everything, and you file bankruptcy, and technically speaking, the bedding company has a secured interest in that bed. Do they really want to repossess a used bed? Is there a huge market to repossess a used bed and then go remarket it? Probably not. So in those instances, they may enter into a redemption deal with you where they say, all right, you owe us, $3,000 still for the bed, but we think the current value is $900. If you pay us $900, you can keep your bed, and we'll upon payment, we'll release our security interest, and you're done. That's the difference between your three options. Again, if you've got questions about that, this is one of those things that's definitely worth talking to an attorney about. Next. You are going to go to a bankruptcy court 1 or 2 times minimum. First time, if you're filing yourself, you'll go into the clerk's office, you file your petition, you pay your fee. If you use an attorney or file electronically, you may not. Your only time going to the court for a lot of folks is when they go to their 341 meeting of creditors. It's called a meeting of creditors. Sometimes your creditors are there. All the time, your trustee is there. So if you file a 7, your 7 trustee is there. If you file a 13, your chapter 13 trustee is there. It's held at the courthouse, but not in the courtroom. It's in another room on the 3rd floor. And this is where the trustee and any creditors who choose to attend can ask questions of the debtor. It's not intended to be a harassment vehicle. If your creditors show up and they start getting mouthy, the trustee or the U.S. trustee may very well ask them to leave or to tone it down. But this is to get clarification. The questions that will almost always come up are, why did you file bankruptcy? What set of circumstances led to the filing of bankruptcy? What kind of debt do you have? What kind of assets do you have? And they're going to scrutinize the information, not only that you filed with the court, like your petition and schedules, but all of that income and statement information that I told you you're going to have to produce before you go. If you say that you only make $10,000 a year, but they're looking at your bank statements and they see deposits of $30,000 and $50,000 and $60,000, they're going to ask you about it. And you better be prepared to obviously address those questions. Even though you're not in a courtroom, you are under oath. You have to bring in a photo ID. You have to bring your social security card. If you don't bring your social security card or you don't have one, get a hold of the trustee ahead of time and find out what alternate info, alternate ID you can use. Right now, I've attended a 341 meeting yesterday. They are doing them over the telephone. It's a little awkward. If you use an attorney, they're asking for your attorney to be able to verify that the person on the phone is in fact your client, the person who filed bankruptcy. If you don't have an attorney and you're filing by yourself, frankly, you have to reach out to the trustee beforehand. They will ask you to submit that information, and they may video conference with you beforehand to, again, verify this person whose ID I'm looking at is the person who's on the screen, who will then be the person that I'm doing the meeting with. Next. Docs to provide. I told you that you're going to receive a questionnaire from the trustee. These are just some documents that show up at least 2 years of your past tax returns, all pages, even the pages that don't seem to have any good information on them. Don't care. They want them all. Most recent 3 months worth of proof of income. If those are pay stubs, easy. If you're self-employed, you better have a profit and loss statement put together. And again, these are minimums. Sometimes they will want more. They will want 6 months, they will want 12 months. So look at what's being requested of you by the trustee. Last 4 months worth of statements for all accounts, your checking account, your savings account, and all pages. Even if the back page of your statement is just a bunch of legalese, or the back page is a solicitation to go into the bank and open up another account, all of the pages, at least 4 months, and for all accounts, your checking, your savings, the little baby savings accounts that you open up for your kids, the account that you're on with a friend or a family member, if your name is on it and your name is linked to it, provide the statements. They, meaning typically the panel trustee or especially the US trustee, they will have more financial information about you when you file than you'll probably be able to get for yourself by just doing a credit bureau report. They will know every account that you are linked to. So again, for instance, I'm on an account with my mother. If she were to get ill, I'd be able to take care of her affairs. If I were to file bankruptcy, I need to get 4 months worth of statements for that account. Even though I don't touch it, because I have the ability to use that account, I need to produce those statements. If you were divorced, you need to produce a copy of the divorce decree, property settlement agreement, child support info, etc., whether you pay it or receive it. If you lease anything or you rent anything, produce those leases or rental agreements. Again, titles and some sort of valuation for the vehicles. And then there are certain special income documents. If you happen to be married but are only filing individually, you still need to produce some income information for your non-filing spouse. This sometimes catches people off guard. Hey, I'm the one that's filed bankruptcy, my spouse isn't. Welcome to Nevada. We're a community property state. They are going to look at the amount of income the household receives relative to the expenses that you're claiming. It doesn't necessarily drag your non-filing spouse into bankruptcy, but it is a tool, for instance, that the U.S. trustee and the trustee are going to look at to evaluate the fairness of your proposed treatment of your creditors. Obviously, if two people are married but only one is filing bankruptcy, it's not appropriate for the person who's filing to list just their income and all of the household expenses. That would make an unfair match. So again, if you are filing but your spouse is not, be prepared to produce income information for them. Likewise, if you're self-employed, in addition to a profit and loss statement, you may need to produce additional information about whatever entity you use, or if you have a sole proprietorship, info about that. If you have a partnership, info about that. Next. We graze against tax returns, again, that it's very, very difficult in most instances to discharge individual personal income tax liability. You need to make sure that any of the refunds or any of the tax years worth of liability that you're trying to discharge meet the qualifications that I talked about before. 3 years old, you filed a return 2 years ago, etc. The other question that comes up very often is, what about my tax return? Well, the big question is, did you already receive it? If you already received it, how long ago did you receive it, and did you already use it? If this is for a tax return you anticipate getting in the future, then we have to figure out, when did you file and how much of that return have you already earned? And so what I mean by that is, let's say for the year 2020, I obviously haven't gotten my tax return for 2020. I've probably gotten my tax return for 2019. And if I got my tax return for 2019 and I used it to try to pay my debts, I used, it to buy groceries. I use it to pay my car loan. All's fair. If I have that tax return and I just stuck it in a savings account, well, you better make sure that that is money that you can exempt, either through one of your other income exemptions, through the tax return exemptions themselves, or for your wildcard exemption. I've got that $10,000 to play with. If I got a tax refund of $3,000, that fits nicely into the $10,000. I've got $7,000 more to exempt. Great. But for 2020, I obviously haven't received my tax return yet. I'm going to file right here in the end of May. Maybe I file in June. I've already earned almost 6 months worth of whatever my 2020 tax return is. So this may delay my discharge. Depending on my history of receiving refunds, if I've always gotten refunds, let's say big refunds, $7,000, $8,000, $9,000, $10,000, and all the years before I filed bankruptcy, the trustee may very well delay my discharge until I receive my 2020 tax refund, which obviously would be sometime in 2021. So do take a look and discuss that if you're anticipating receiving a big refund. That may dissuade you from filing at a particular point in the year. When you receive that refund, you may not have to turn the whole thing over. You may need to, if that's part of the way that you're funding your 13 plan, for instance. But you do, at the very least, need to make sure that you either exempt it or that you're prepared to turn it over. And again, those questions do get very specific to the individual. It's another good thing to bring up with an attorney. Next. Again, last time I'll breathe it because it just seems to be a very frequent question. These are the rules of trying to discharge taxes in a Chapter 7. These are summaries of the rules. It does get more complicated than this, but there's a 3-year rule, the 2-year rule, and the 240-day rule. Again, the due date for the return was at least 3 years ago. The tax return was actually filed for those tax years at least 2 years prior to when I filed bankruptcy. And then, of course, the IRS actually assessed those taxes at least for 240 days before I file. Meaning, if I'm still in dispute with the IRS and they haven't yet assessed it, I haven't started that clock yet. If I haven't paid taxes for 4 or 5 years and all of a sudden I'm getting overwhelmed and I'm thinking, man, I need to just file bankruptcy, pump the brakes a little bit. Talk to a bankruptcy attorney. You may also need to talk to an accountant or a CPA because you need to get those returns filed with the IRS to start that 2-year time frame to even begin to think about filing bankruptcy to try to discharge the amount of tax that was due. So, again, big caveats for anybody that's trying to discharge tax debt. Next. Mortgages. Mortgages, tend to be the biggest type of debt that somebody has when they file bankruptcy. Again, I talked about how when I file bankruptcy, if there's a foreclosure already in process, it means the creditor has to stop, but not permanently. If you are behind on your mortgage and you're in a Chapter 7, that creditor, again, has rights in that property. They may not be able to come after you and sue you for a deficiency judgment or any extra money that's owed, but they do have the right to try to go to the court, ask for what's called relief from the automatic stay to be able to go forward with their state law foreclosure. What relief from the stay means is when you file bankruptcy, there's an automatic stay. It's kind of like an invisible iron curtain that comes down and protects the creditors from getting to you or your assets. The exception being, one, if a creditor has rights in assets like a mortgage and they have a recorded deed of trust against your house, they can go to the bankruptcy court, they can request relief from the automatic stay. If the court grants it, that's kind of like taking the house out of the bankruptcy and allows the bank to go forward, foreclose on that property. The big difference is if I obtain my bankruptcy discharge, they can foreclose on the house. They just won't be able to come back at me if there's anything additional that's still owing after they do that. Chapter 13 is a little bit different. If the bank wants to get relief from the stay, they're going to have a delinquency in post-petition payments. That means from the moment that I file bankruptcy, that's my petition date. From that moment on, all of my regular monthly payments that have come due are, basically what governs what those secured creditors' rights are. Because in a 13, remember, you're trying to reorganize all of your debts. So everything that I owe, let's say I'm 6 months behind on my mortgage. Well, I'm going to propose a plan in my 13 to figure out how I'm going to catch up on those back payments. I may be paying all of my credit cards and my dischargeable medical debt and so forth. I may be paying them pennies on the dollar, which then frees up what income I have to be able to catch up, those missed mortgage payments over that, again, 3 or 5 year payment period of my Chapter 13 plan. The only way that the bank will be able to go forward and try to get relief from the automatic stay, assuming again that I confirm my plan, is if I fail to make my post-petition mortgage payments. So if I file right now in May, in my Chapter 13, I got to make my June payment, I got to make my July payment, I got to make my August payment. It does not matter, at least for the purposes of relief from the automatic stay, that I already missed 6 months worth of payments. Those are the payments I'm fixing through my plan. Going forward, in order to keep my house, I'm going to make my post-petition payments in the 13. The other thing I can do in a 13, if I have, let's say, a second mortgage or some other kind of encumbrance on my house, if there's not any value to support that second mortgage, let's say my house is worth 200 grand, my first mortgage is 300 grand. So I'm already underwater on just my first mortgage. If I have a second mortgage that's 50,000, there's no equity in that house that's supporting that second mortgage. I can use a process in Chapter 13. The kind of nickname is we were stripping off that second mortgage. I can basically turn that second mortgage into an unsecured loan, get it off the title to my property when I finish my Chapter 13 plan. So a big advantage, a little bit harder to take advantage of these days with the values of houses being where they are in Reno. But for some folks, it's a real big advantage of filing a 13, because assuming you get all the way through your plan, if there was no equity to support that second mortgage and I filed the appropriate motion with the court and it was granted, I may be able to get out from underneath and start growing equity a lot faster after my bankruptcy case than I did before. Next. Now, we talked already about things you don't want to do in bankruptcy, i.e. hiding things, hiding assets, hiding payments, hiding money. There are tools that the trustees or your creditors have at their disposal to really get you in some trouble for this. One, and you'll see it as one of the questions when you fill out your bankruptcy paperwork, preference payments. $600 or more made to any creditor, any one creditor, within 90 days before you file. This can be basically clawed back from whomever you paid it to, unless it was a payment made within the ordinary course of business. If my mortgage or my car payment or my student loan payments are over $600 and I was just making my regular payments to them right up until the time I filed bankruptcy, that's fine. What this preference payment is trying to do is dissuade the one creditor that just bugs you and calls you 15 times a day, where you finally just lost it before you filed bankruptcy and said, here, take $2 grand and stop calling me. If that happens, obviously the whole point of bankruptcy is they're trying to make sure that all of the creditors receive a pro rata equal payment. It's not going to say that somebody you owe $2 grand to gets paid as much as somebody you owe 50,000 to, but they're all going to get their kind of pro rata share. With a preference payment, they're trying to avoid the creditor that for one way or another, outside of the ordinary course of business, got more than $600 within 90 days of you filing. The other situation, they're also trying to avoid the situation where you pay back a friend, but not your credit card. So if I owe my friend Bob $2,000 and right before I file bankruptcy, I say, Bob, I'm getting ready to file BK. Once I do that, I'm not going to be able to pay you after. Here's the $2 grand I owe you. Have a nice day. If they see that on your bank statements, if they see that in your financial records, they will be able to go to Bob and claw that away from him and put it back in your bankruptcy estate so that the trustee can dole it out evenly. The other one that comes up, the other kind of bad act correction tool, if you will, is what we call a fraudulent transfer. The debtor is basically giving away, hiding, selling, transferring in any way, shape, or form anything that should have belonged to the bankruptcy estate. I will just plant the seed that sometimes, depending on what kind of bad deed the person did, even if it would have been something that's exempt, if it's not something that you declared because you were trying to hide it, you may lose the ability to claim an exemption on it. There's case law that goes over the place with that. That's again, a conversation for another day. But let's say, for instance, you have something that you know is not exempt. I have a, oh, what the heck? Let's just say I have a Ferrari in the garage, right? My daily driver is my Ford, but I have the Ferrari in the garage, and it's got a lot more than 15,000 worth of equity. I've already used my wild card exemption. Let's say this Ferrari is worth $150,000, something ridiculous. I've got $150,000 Ferrari. I can't exempt it, but boy, I really want to keep it. So I previously have a title on this Ferrari, and I sell it on Craigslist for $2,000, or I give it to a friend and say, hey friend, I owe you $10,000, but I'm giving you the Ferrari. You hold on to it for me, and after my bankruptcy is over, then you agree to sell it back to me or give it back to me. It doesn't have to be for money. Especially with vehicles or any other kind of asset where there is paperwork involved, the U.S. trustee or your creditors will find out. They will be able to look at the intent that you transferred this thing, and at least 2 years before you file bankruptcy, they again will be able to kind of claw that back from whomever you transferred it to, and then it's got huge ramifications. One, you're losing the asset. You don't get to get any value out of it. If you had sold it pre-petition, got money, you might have been able to use that to pay down your debts. Well, if they have to use a fraudulent transfer action to get that Ferrari back, you may lose the ability to get any kind of value from it. Two, depending on the intent that they determine that you transferred or sold or gifted or hid this asset, it may lead to you getting denied your discharge. So they will put you through the rest of bankruptcy. They will liquidate everything in your bankruptcy estate that's not otherwise exempt, and then they'll kick you out. They'll kick you out of bankruptcy and say, no discharge for you. That may be, for a limited period of time. It could be for a really long time, and then you're really in trouble. So again, do not do this. Do not hide assets. I had a situation where I had a debtor who filed bankruptcy. He had a very, very large piece of construction equipment, a huge front loader. He basically said that he had given this to his mother for some sort of debt that he had. Again, this is almost $1 million piece of machinery. His mom was in her 90s, lived in Lake Tahoe. I couldn't get a straight answer from the debtor. I represented the trustee, so then I had to interview the mom, and I had to be the jerk that asked a 92-year-old lady if she really used a huge multi-ton front loader to clear snow from her driveway. She admitted that she not only hadn't driven it before, couldn't drive it, had no idea why her son just parked this thing behind her house and told her to hide it. And at that point, he really got in trouble, as you might imagine. So don't do it, don't do it, don't do it. They'll look at whether, again, the intent of you doing it was actual fraud or constructive fraud. Usually the look back period is 2 years, but there are exceptions. They can look further back, particularly if you put things into a certain kind of self-settled trust, which are really popular in Nevada. If you try to put a bunch of things into a self-settled trust, they can go as far back as 10 years. So really big questions. It's questions when you fill out your paperwork. There are questions when you go to your 341 meeting. Did you basically sell, gift, or transfer anything of significant value before you filed? Now, if you had a $1,000 car that you gave to your kid because she was going out to college, that's probably okay. Most instances, that's okay. If you sold something before you filed bankruptcy to get money and then use that money for debt payment or living expenses, that's fine. Frankly, that's something that you're supposed to do. But if I sold an asset, got 50 grand, and then sent that 50 grand to, a Swiss bank account, that's a problem. So do not hide it, and do not think that you'll get away from it. They will track this down, and it could be some real bad ramifications for you. Next. If you are filing without an attorney, there are options where you can still get some help. One of those options, obviously, is Nevada Legal Services. They have folks that can help you fill out the paperwork. It's not terribly difficult. In 2015, they did make the forms a lot easier for folks to fill out. But again, and I know what it's like, you have, I've gotten many times where the boxes of all the statements and notices and threatening letters are all kind of jumbled in there together. And somebody needs to sort it all out and figure out which category this debt goes to and which category this debt goes to. There are folks in town called petition preparers. Some are great. Some, charge in the neighborhood of $150 to $200. They will help you prepare your petition and schedules. And just for the benefit of them filling all that out and knowing how to fill the things out, it may be worth it for you to pay that if you choose to do it. You don't have to use anyone to file your petition and schedules. If you look at the forms and think you can do it, gravy, you saved yourself some money. Do not pay an exorbitant amount of money for a petition preparer, and do not accept legal advice from a petition preparer. We've had several, unfortunately, in Northern Nevada that have pushed that limit and have gotten in very deep trouble. The bankruptcy court maintains a list of those individuals' names that are barred from providing bankruptcy advice in any bankruptcy court, I presume, but particularly Northern Nevada. If you are going to use a petition preparer and you're scared about that, contact the court and get that list. But like I said, there are some that are great. If you don't feel like you need a lot of legal advice about filing bankruptcy, you just need help filling out the paperwork, might be a great option for you. Again, Nevada Legal Services, and many times in the past, has also helped folks. They will have volunteers that will assist in helping you get your petition and schedules put together. The old caveat that we probably all heard, ignorance of the law is no excuse. So if you make a mistake, more often than not, the court will help you and say, you know, this probably wasn't what you intended to do, but you know, in certain instances, there can be things that backfire. That could be something trivial, like you just put something on the wrong page. There could be something silly like you forgot a zero. Again, depending on your intent. If it was an honest mistake, it was an honest mistake. But if you filed Chapter 7 thinking that you could catch up on your payments, well, that's a big one, because you need to be in a 13 to try to do that. And the court may give you an opportunity to convert your case after you file, but they may not. So, again, if you've got significant questions, that would be where you want to utilize an attorney. If you're taking affirmative acts in your case, if you're trying to strip off a loan, you're trying to modify something through a plan, you need to abide by the rules that we have for servicing and noticing those folks. Filing deadlines is a huge thing. There are certain things that you have to file, particularly like your notice of taking your second education class, your notice of fulfilling the terms of your plan and being eligible for discharge in Chapter 13. There are things that you have to do. And the good news is the bankruptcy court's website does have good kind of checklists for you. Definitely get those before you file. If you're using an attorney, they should monitor all this stuff for you. In addition to the federal bankruptcy court code and the federal bankruptcy court rules, we also have local rules just for the courts in Nevada. If you're going by yourself, you may want to take a look at those as well. Next. All right, there are situations where you don't have the benefit of time. Hopefully, by virtue of anybody taking this class, you do have the benefit of time. You've collected all of your information about your assets, all your information about your debts. You've filled out your schedules and statements. You pulled a credit bureau report. You've listed every single creditor that you could possibly owe money to. You've racked your brain. Do I owe anything to anybody else? Are there any assets? Do I have that savings bond that grandma gave me 25 years ago? You've racked your brain. You fill out all your statements and schedules just perfectly, and hopefully won't have to make any changes after you file. But there are situations where, here we are on a Friday, and you get notice that on Monday there's, you're going to get foreclosed upon. You can do what they refer to as an emergency or face sheet bare bones bankruptcy. The minimum documents you need are the petition. Again, you've got to take that class, so your certificate of compliance, your schedule of creditors, and a mailing matrix. And that mailing matrix is a list of your creditors and their addresses. That can be super basic. At a bare minimum, if you're trying to bar a foreclosure or stop a foreclosure, I should say, you'd want to list that creditor and their address. You need to get these things filed and filed correctly, however. And if you file kind of a bare bones situation, you need to get them corrected. And you also need to file the remainder of your required documents within a 14-day period, or you run the risk of getting dismissed. And remember, ultimately, if you don't schedule a debt, they're not going to be included in your discharge, and they have the ability to pursue you as if you had never filed the bankruptcy in the first place. Next. All right, good places to start. Now that you've probably gotten inundated off more bankruptcy information than you wanted to know, the Bankruptcy Court's website for the District of Nevada, I think, is a great place to start, not only because the wealth of information that they actually have there, they have videos. They have a glossary. They have a breakdown of the differences between a 7 and a 13. They go into more depth about, the ultimate effect of your discharge and so forth. And that's all linked through the bankruptcy court's website. And you can trust the information because it's obviously coming from the horse's mouth. The U.S. court's website for basically all federal courts does also have some additional information there. You can link to that off the bankruptcy court's website. So this top link here, the nvb.uscourts.gov, will get you to our bankruptcy court's website, and you will see like file folders. There's little tabs up top. It'll say, filing information, and one of the links off filing information is bankruptcy basics. Go there, learn a little bit more. It'll link you to what the current median income figure is. It'll link you to what the maximum amount of unsecured debt that you can have, and so on and so forth. There are obviously print resources. Absolutely pick the newest resource you can get. I continue to see Washoe County Library System getting new books every year. Get the newest one you can get. 2019, 2020, great. In no circumstances should you ever use anything that's before 2005. In 2005, we completely redid the bankruptcy code. All of that stuff is borderline worthless. Post 2005, again, don't trust the dollar amounts that you read in any kind of book because those change annually and may change even more frequently than that. And as is usually the case with the internet too, there's some good information on the internet, certainly after we talk about the bankruptcy court's website. If you're just going on to another law firm's website or reading an article online, really, really take that information with a grain of salt. No two debtors are the same. There may be different circumstances that apply to one that don't apply to another. Depending on what state you're in, could be a world of difference. Nevada has a big homestead exemption. Florida has an unlimited homestead exemption. California has a tiny homestead exemption. So if you're reading an article as you sit here in Nevada and it's from a Florida attorney saying you can exempt your whole house, it doesn't matter how much equity you have in it, you think you can do that. Likewise with California, you may think you only have a limited homestead exemption. So please take anything else that you read on the internet with a very big grain of salt. Next. This is what that bankruptcy court, the District of Nevada Bankruptcy Court website looks like. Again, that little filing system up top, you'll see the filing tab. That's where you'll see the bankruptcy basics. You'll get a list for the court fees and so on and so forth. There's also a special category for folks that are filing without an attorney, i.e. pro se or pro per filers. If you look kind of right next to that, and it's real small print, but one of the other tabs is rules/forms. That's where you're going to get your official federal rules of bankruptcy procedure, your local rules, and just about every form that you could possibly use in bankruptcy, unless you're trying to do something affirmative like file a motion. And again, if you need help with that, that is where I would absolutely refer you to an attorney because you may need to draft a motion. And there's obviously not going to be a printed prefab form for that kind of thing. But all the petition, the schedules, everything else is on that forms tab, fillable PDF. If you make a mistake, you can just change the one you already have, start over again, whatever you need to do. To that end, if you make mistakes or need to add or change the information once you file bankruptcy, you can do that. In certain instances, there's a fee that goes along with it, somewhere in the kind of $30 to $40 range. But you're absolutely going to save yourself a lot of time, heartburn, and money if you list everything correctly when you file. Next, I think that maybe, oh, sorry, this is just when you click on that bankruptcy basics, you'll see that there's videos on the left. There's a litany of information on this, and honestly, it's a really good overview. It would dovetail into what we've talked about today, and it's super exciting stuff. I say that pretty facetiously, but sometimes it may be helpful for folks to actually read it rather than just listening to somebody like me drone on. So definitely take a look at that before you file. Next. All right. Once you've kind of gotten the lay of the land, where to go and get help? Well, obviously, by virtue of hosting this class today, Nevada Legal Services can help get you either attorney help or kind of non-attorney help. And by virtue of attorney help, if you determine that, boy, I probably am going to need to file a 13, I don't know where to start. I'm going to need help getting my plan together. Nevada Legal Services may help you get paired up with an attorney who will provide their services for zero or next to zero. In some instances, you're still responsible for filing paying your filing fee. And again, the attorney can help you apply for a waiver or to get that broken up in installments. But if you would feel more comfortable, whether you're filing a 13 or 7, if you'd like the guidance of an attorney, do work with Edith at Nevada Legal Services, and they can help you hopefully get matched up with an attorney that's willing to take it on, hopefully for complete pro bono, and you'll save yourself a lot of money and probably heartache because you're dealing with somebody like an experienced bankruptcy attorney who's done it a lot before. Another resource, if you are looking, don't believe that you'll necessarily qualify for a pro bono attorney, but you do want to find a competent, a reputable bankruptcy attorney. The State Bar of Nevada that governs all licensed attorneys has an attorney referral service. I definitely recommend calling them. I believe there's also some information on their website, but that way you can make sure you're getting linked up with an attorney that, 1, is licensed in this jurisdiction, 2, has held themselves out as knowing how to practice bankruptcy, and 3, and most importantly, isn't in trouble. And by isn't in trouble, I mean with the State Bar. The State Bar is not going to refer anyone to an attorney that is in the middle of some sort of disciplinary proceeding with the State Bar. So definitely better than the phone book. Don't just pick it off, the size of the ad. You can go through the State Bar and make sure that they're a licensed attorney. That's it for my presentation, guys. I do strongly recommend getting any questions that you may have about the bankruptcy process answered by a competent bankruptcy attorney. And in Reno and Northern Nevada, we have a lot of good ones. We have a lot of folks that have been doing this a really long time. There are as is often the case, anytime we go through a big financial change like we're going through now, and like we probably will, especially when we get into July and August, there will be a lot more attorneys jumping into the bankruptcy arena. Again, I just caution you and recommend finding somebody that actually has experience with bankruptcy. If you feel confident going your own route and filing yourself, going pro se, if you have ever done your own taxes before, you can certainly fill out your own bankruptcy paperwork. If your estate is simple, if everything that you have, you believe that you can fit into those exemptions, and your case is relatively simple, you just need to get rid of some consumer debt or some, consumer debt, including credit card debt or medical debt, it may be a simple enough process that you can go and get everything prepared yourself. So again, just recommend it. Going throughout the process, pull all those forms, the statements and schedules, take a look at it so you understand the kind of information that they'll be requesting. Highly recommend pulling that credit bureau report. Highly recommend organizing things and getting a hold of those statements before you file. There's nothing worse than filing and then kind of feeling like, oh boy, we've got that monkey off my back, and then having a very tiny amount of time to get all those statements together right before you go into a 341 meeting and not getting it. It's all jumbled and disorganized. Don't put that on yourself. Either get help in doing it or do it yourself, and you'll save a lot of heartache. Other than that, I wish you all the very best of luck. And like I said, if you have any questions about what Nevada Legal Services can do get a hold of Edith, and we'll send you on your way.
Thank you so much, Seth. We really appreciate you doing this. I hope you have a great weekend.
Thank you, Seth. Thank you, Ray.
Thanks, guys.
Bye-bye.
Bye-bye.